Well, today I'm going to take you through a case which is coming in, a legal journey for a child who's less than 14 years old. But it's not just the journey of this child, but it is the conscience of the entire nation which today gets jolted. This is a child less than 14 years of age. We are not going to reveal any more details about this minor child. She had been forced to undergo a harrowing assault, a harrowing sexual assault. Finally, the man who assaulted her was put on trial. A trial court even convicted the sexual fiend. A high court then upheld it, saying this is rape. And then, 7-8 months later, the Supreme Court has come out and said, this is not rape. What really happened in a system where convictions are rare, pending cases soar? This case exposes the fragile line between justice and also justice for whom. But first, let's tell you what really has happened. Let's get you the details of this case. Then you and I are going to look into the issue. Are the laws safe enough for our children? Are they adequate to protect the children? First up, the timeline. What really happened in this case of sexual assault against a minor child? In July 2022, the trial court gave a verdict. That verdict was of rape under pocso as well as the IPC. Well, in fact, you also have the Chhattisgarh High Court following that, as you can see on your screens, in January 28, 2025, earlier this month, saying that this is rape under pocso as well as the IPC. The Supreme Court, however, just yesterday has said this is not rape. This is aggravated assault, sexual assault against a minor, but not rape under the IPC or the pocso. Let's also bring to you the traumatic experience of the minor girl. These are details which are coming in from the FIR. We want you to hear the voice of this child, a child who was robbed of her innocence, robbed of her childhood with a trauma perhaps which is going to last her for a lifetime. This is what the child says. Mind you, she was less than about 12 years old. She said, he touched me, the man who has been convicted. The convict, he touched my place of urination with his hand. He had also opened his pant and he touched himself. He tried to make me hold his private organ as well. I bit his hand and I ran away. Now viewers, it's not easy for me to read this. It's not easy for you to see this. We are going to again show you right from the beginning because it's important that we understand what this child has been forced to go through. She says that he touched my place of urination with his hand. He also opened his pant. He touched himself. He tried to make me hold his private organ. Then I bit his hand and I ran away. It's not easy for me to say it. It's not easy for you to hear this. It's the ordeal that the child had to endure. But this is what the FIR states. The High Court, the trial court, said this was rape. The Supreme Court, however, this is a Supreme Court bench which is led by two justices, Justice Ahsanuddin Amanatullah and Joymala Bakshi. They did not agree with the High Court's ruling. What did they say? Why did they disagree with the High Court as they set this man free of the charge of rape and diluted his sentence? Well, the Supreme Court said that this is no charge of penetrative assault. That the case of penetrative assault is not supported by medical reports. It is also not supported by the minor nor her mother. It's sexual assault, but without penetration. Supreme Court also said that it is going to scrap the conviction for rape under IPC and pocso. Said that the conviction is only going to be now for aggravated assault on the child. The sentence was then reduced to 7 years from the earlier 20 years, which was granted by the Chhattisgarh High Court in January this year. High Court said, sentence him to 20 years of jail. Supreme Court, however, said this is not a case of rape. It is aggravated sexual assault against a minor under 12 years of age. So give him 7 years of jail time. But let's break down the specifics when it comes to the section. Important for us to understand what the accused, the guilty rather, has been first convicted in the High Court and why this differs from what happened in the Supreme Court. You have that entire breakdown on your screens. Well, the High Court's conviction held him guilty of rape of girl below 12 years of age, and this was under section 376 AB of the IPC. This covers penetrative sexual assault. The punishment of this was 20 years, hence he was given 20 years. However, the Supreme Court's conviction said that he is only guilty under section 354 of the IPC, which is assault to outrage the modesty of a woman, which covers physical acts, forceful actions, but not penetrative. The punishment for that is 1 to 5 years. Also on the pocso, let's explain to you how it differs from the High Court to the Supreme Court. The High Court in its conviction held him guilty under section 6 of pocso, which is rape of a child, rape of a minor. This covers penetrative sexual assault. The punishment was 20 years to life. The Supreme Court's conviction is section 10 of the POCSO Act, which is sexual assault on a child, which covers sexual assault from a position of trust, a man who holds a position of trust, of faith. And the punishment under that is 5 to 7 years. This is what he has been convicted of by the Supreme Court. But before I take you through the details of rape laws in India and why it is important to have a stringent law in place, the Supreme Court bench, comprising of CJI B.R. Gavai and Justice K. Vinod Chauhan, have suspended the jail sentence of a Christian pastor, Father Edwin Pigares. Now, this is a parallel case that we are talking about. This pastor was convicted of raping a minor girl. Now, viewers, the rape convict pastor has also been granted bail. It was said by the Supreme Court that he has already spent half of the jail term, and mind you, the convict's appeal against the High Court's conviction ruling are still pending. But despite being a rape convict, the Supreme Court reduced the sentence imposed upon him by the special court from life imprisonment for the remainder of his natural life to rigorous imprisonment of 20 years without remission. These are two separate cases we are discussing, but what is alarming, perhaps, for the viewers is the state of POCSO cases. Let's remind you, it's all about ensuring that laws are not just implemented but also are stringent enough to work as a deterrent. But look at the backlog which is piling up when it comes to the POCSO cases. The number of cases which are pending, there you have it on your screens, number of cases which are pending is 2.43 lakh POCSO cases which are pending. What about the conviction rates? Let's tell you how exclusive POCSO courts have a conviction rate only of 17.6%, not even 18%, 17.6%. The conviction rates in fast-track courts is 7.2%. That's the conviction rate. Regular courts, POCSO cases, have a conviction rate of 5.5%. But let's look at the increase in the number of cases. There has been a 31% rise in the cases between 2012 and 2024 in those 12 years alone. 31% rise in cases, and yet we are looking at cases where some of those who have been accused are what many saying let off easier. Well, the question that has haunted India for decades now resurfaces. Should rape laws be made more stringent? After all, in Saudi Arabia, you get a death penalty. In Madagascar, you get castration for rapists, as well as life imprisonment, either or. In Sweden, if there is no consent, it is rape. There's no need to prove rape. In United Kingdom, it's going to be life sentence. Let's also quickly take a look at some of the other controversial decisions coming in by the Indian courts which have in the past raised eyebrows. Here's one coming in from the Allahabad High Court earlier this year itself, saying that she, which is a rape victim, invited trouble upon herself. There's another one coming in from the Allahabad High Court again. This one was earlier this year as well in March, saying grabbing breasts and breaking the pajama string of the victim is not rape. Here's another one, and this is an interesting one which is coming in again from the Allahabad High Court, saying live-in relationships are against Indian values and ethics. Then you have this one coming in from the Karnataka High Court. It is unbecoming of a woman. Why? To sleep and fall asleep after the sexual assault on her. Then you have the Delhi High Court. In 2017, it said that the rape charge is being used as a weapon of vengeance, which is by the victim. Another one from the Delhi High Court. 14-year-old consented to the sexual abuse. These are some of those questions which we are going to be raising today. Let me go across to our panelists. Joining us today on the show, we have Rekha Agarwal, who's a lawyer. Another advocate joins us, Rishika Dhawan. First, I'm going to be coming across to you, Rekha Agarwal, because it's important for us to understand. If we look at the specifics of rape, what one can understand, and I can only explain what we can understand as a layman, and you as a lawyer will perhaps understand better, that if it is not penetrative, then it's not rape. But what about the trauma, the ordeal that the child has to undergo? Does that get taken into account, whether deciding it is rape or just aggravated assault?
What I would like to say over here that, first of all, I would like to remind the viewers of the change in the laws regarding rape, which happened post-Nirbhaya.
Yes.
Very strong amendments in the definition of the term rape under Section 376 of the Indian Penal Code, where, if you may recall, that at the time when the Nirbhaya case was being tried, the lawyer of the accused person had even argued in the court that there was no rape because there was no penetration of the victim's private organ with the accused's private organ.
Absolutely.
And the only thing that had been put inside the victim's private organ was an iron bar, a steel bar or an iron rod, caused grievous injury and ultimately led to her death. And at that time, there was a big, huge cry all over the courts in Delhi particularly. And in fact, even the Bar Council had issued a notice to the lawyer as to how he could make such an appalling and obnoxious argument in the court that the victim Nirbhaya had not been raped. And it was post this when the judgment of the trial court in a very record time had given a verdict that yes, indeed, despite the fact that there was no penetration by the private organ of the man into the lady's private organ, it did amount to rape.
Absolutely.
And it was because of that there was an amendment in the criminal law regarding the rape, and there was a Justice Verma Commission, and therefore the definition of the term rape was very widely defined to include all sorts of sexual assaults which may take place upon a woman's body. At the same time, there was an amendment even under Section 354 of the Indian Penal Code, which earlier was just violation of the woman's dignity. Amendments under Section 354, which included even, stalking and, virism, things like that. The penal terms were also kind of booked under the law at that time. So all these kinds of the law regarding violation of a woman's...
This is the tweaked laws. I agree with you, but Rekha Agarwal, my question remains. Do you agree with the Supreme Court saying that this does not tantamount to rape, either under IPC or pocso?
Well, first of all, I would like to state over here that until one reads the entire facts, what about the allegation in the charge sheet, it would be a little, kind of a presumptive on my part to pass a judgment or make an observation. However, in my view, since POCSO Act is also very vast and covers all sorts of sexual violences against any child, whether it is a girl or a boy, therefore, both the laws put together, they should have actually, without reading the evidence of record, I cannot say so, but since there has been a complete trial by the trial court in Chhattisgarh,
right,
the judgment has been upheld by the High Court.
Absolutely.
So it is very rare, after concurrent findings are there, after concurrent findings of the lower court and the High Court are there, for the Supreme Court to kind of differ and pass a judgment that and reducing the sentence to 1/3. Mind you, from 20 years it has been reduced to 7 years. So therefore, I do think that despite the fact that there was no actual penetration of the sexual organ, but still the view that has been held in the after Nirbhaya case, that should have been upheld and the person should have been punished for rape.
And that's very interesting you say that, because Rishika Dhawan, I'm going to come to you here, because even the State Council, while arguing the case, saying that look at what the victim had to endure, it should be a fit case for rape and not just sexual assault, because this predator deserves no mercy. Rishika, what do you think?
So, Meghna, on the penetration part, now, while I completely concur with Rekha ma'am here, you need to have a look at the actual facts. And there are two concurrent judgments basis which the punishment had been decided and rape had been defined. So the judgments should have been elaborate enough to make it fall in the relevant section, whether it's a sexual assault or penetrative sexual assault or aggravated sexual assault, penetrative sexual assault. So all these sections have been duly defined and each one has a different quantum of punishment defined in the subsequent sections. So to go to which section, the courts would have defined the whole act, the evidences, the testimonies and the MLC to come down to a punishment. Now, without the facts, it's very difficult to come down to saying whether it was rape or it was merely a sexual assault by which the punishment has been reduced to 1/3. However, the interpretation of criminal law is somehow strict.
Okay.
You need to understand the exact statements, the testimonies, the MLC, and the exact status of the individual when the incident would have happened to come down to a conclusion. Here, if we see, if the two courts have already defined a certain act as a rape, now it has been stated to be a sexual assault. This poses a lot of question on the interpretation of two lower judges, lower courts, and then the Supreme Court. So reduction, it's very difficult to come down to a conclusion whether it is right or wrong, merely on the portion of the judgment that's become public now. But as far as understanding, our courts and our judges would have obviously analyzed everything. So for that to come down to deciding the outcome, it is questionable, yes. But whether it is right or wrong, I don't think we will be able to decide it here in this discussion.
Absolutely. We can't decide here as to whether the Supreme Court was right or wrong. What we can do, however, is bring the facts to life. You had a trial court which said that it was rape. You had the High Court who said it was rape. Two concurrent verdicts came out. You had the Supreme Court who said it was not rape. We also told you here on Blueprint Explosive Exclusive how there are several other countries who have way more stringent laws than what we do. But alas, this is where we stand right now. So the question remains, are the laws that we have under IPC, under POCSO, safe enough for the girls? Yes, it's stronger now, but is it safe enough to protect our children? We let you, the viewer, decide. Well, I appreciate it for joining us, Rekha Agarwal, as well as Rishika Dhawan here on the show. Without a short break, don't go anywhere.